And here we go, State of Texas versus Jordan Edmondson. Right out of the gate, notice how calmly the judge frames it. But make no mistake, this isn't just routine paperwork. Behind these words is a case involving a killing, $1 million bond, and the potential unraveling of a young defendant's future.
It looks like it's going to hit New Orleans.
What? That's a neat place. So 23 CR 2076 is now called the State of Texas versus Jordan Edmondson. That's you? He's present with Mr. Lewis, your attorney and the state's attorney. Go ahead, Mr. Mark.
Judge, just the last city, this information to the board did not find and treated from the top as a juvenile, as a minor. Court wanted me to check into that, see what I could find out was like diagnosis of that patient.
Yes.
Happily confirmed that he was getting treated for depression, and it's on a prescription of Zoloft.
Zoloft.
Yeah, he was taking for
Okay.
and that was just still not his any type of plan that he was having.
Okay. All right. So, anything else to add to that changes what you're going to be doing?
No, Judge. After we gone here, I asked for $1,000. Of course, you want to know more about that. Decisions.
Okay. Well, so what about his addiction? So, this time.
I don't see it have anything to what we're dealing with.
Do you have a prescription for that? Are you taking it now?
Yes, sir.
Oh, what about that?
Well, just,
Hello? I mean, that's kind of weird.
well, just, there were issues with that, with him being brought and treated by his mother as a minor, something that I will be speaking to the state about, but as far as any type of, concerning him not being on his medication, anything, while he's being custody.
You're saying that's not a problem.
No, sir.
That didn't, nothing to believe it caused his actions.
You see on that? No, sir.
But
Frank?
you're going to have to help me on this when we look at a bond, among other things, of course, criminal history, circumstances of the crime at issue, criminal history.
He doesn't have any as an adult, Your Honor. I don't remember specifically what he has as a juvenile. I can look at it really quickly for you, though.
Oh, okay. Oh.
Pause for a second. The judge is breaking down how bond decisions are made, criminal history, nature of the crime, and circumstances. Think about it. If you were in that chair, would your past weigh heavier than your present? This is where the law tries to balance fairness with public safety.
Little or nothing. So, where were we on this last time? Where did we end?
That's where we end. It's going to top issue 2 years ago. And I think that was the last thing in regards. We have was a plan where we will be anything like that.
Right now, his bond is $7 million
Legally,
by JP.
just
I don't think he doesn't have a
He's
juvenile
now-
history.
$900,000. Right. Okay. So, parties get to add any information to help on an informed decision here.
I would just like to point out to the court that the victim in this case was shot in the back 8 times. We do not believe that the bond needs to be lowered in this case. As far as we can tell, it was a pretty cold-blooded killing.
Just that.
from our position, Judge, there are some circumstances actually that happened around the situation. Only other witness involved in this case is my client's mother. I don't have any access to her. I don't know if she's acting exactly she's telling us currently, other than her statement she made at the time. But as far as talking with my client, there are some circumstances that definitely
8 shots in the back. Let that sink in. The prosecution wants the court and you to see this as cold-blooded murder. But the defense? They're hinting at self-defense. Here's the problem. Self-defense and being shot in the back don't exactly go hand in hand. What do you think? Does that argument hold up? Or is it a legal Hail Mary?
caused the situation to escalate. So point involved. It was more. I believe it was more a domestic situation than was told.
This is all kind of abstract. That's not helping me understand the circumstances of the crime. That won't affect my my decision, unless you want to articulate a detail better.
Well,
I don't know what you're driving at,
Judge,
Marvin.
my position, I think, is more self-defense. Like I said, from talking to my client, understanding.
No, but you got to do better if you want. If you're shot 8 times in the back, your self-defense is kind of a weak argument.
Well, I think
Because there's no way you're going to be defending yourself if somebody gets shot 8 times in the back. If that's all there is, then I'm here.
right. Judge, I believe it happened after a struggle over a gun. I believe my client mechanic. This was a result of that. It's just more things. Of course, at this time, I would rather talk more with my client on.
Well, the bond is now $900,000. I don't have anything that helps me change that, other than abstract statements.
Right. Just of course, in previous hearings, his aunt was here to be able to testify to the circumstances he would be differently from where he was at this time. Her, his acts would represent.
This moment is brutal for the defense. The judge calls it out directly. If you're shot 8 times in the back, self-defense is a weak argument. That's legal reality clashing with defense strategy. Sometimes, courtroom battles are less about winning the argument and more about minimizing the damage.
Shot bond conditions. And I saw the lead from his bond. House was GPS monitoring. He was in school at the time. His Congress has made allowances so he could continue his education even through home school. And so, Judge, we were asking the court to consider all of them in term while.
Hey, what day of Well, 2020. Please. What day of the week?
Friday.
He was supposed to be at school that morning, Your Honor.
He was.
Yes.
That's why I'm trying.
Well, Judge, I believe
And this happens at 9 o'clock when he should have been in school.
yeah,
So he's not in school. What point is he's in? What is the point you're making? He was in school at the time, and he really wasn't in school. If he was in school, he wouldn't have shot somebody 8 times in the back at that location anyway.
right. And Judge, as far as that situation was a situation where he had left to go to school, came back home, came back to the house. That's what the argument seemed happened to him. And
And then I find there is no evidence that leads me to believe that the bond that was set is unreasonable, based upon the circumstances of this case. That is, the deceased suffered multiple gunshot wounds to his body at 9:01 is time at 9 o'clock in the morning on September 12, 2023. Home police responded to the victim of the shooting. Do you have anything else as far as I have this probable cause affidavit? Is there anything else that wants to help the court with on any kind of other reports?
According to his mother, who is the eyewitness, there was some argument over some money that the defendant believed had been stolen from him. And when the mom walked away to go find the money, she comes in and he shot the victim in the back and in the neck. And he immediately left with the weapon, which we have on the Ring camera footage.
You had a chance to see that.
Absolutely.
Then, court, again, the circumstances of this crime.
Here comes the emotional trigger, money. The mother says the whole fight began over stolen money. That's a classic spark in domestic disputes. But what followed escalated into a deadly tragedy. Think about how many cases start with something small, but spiral into irreversible consequences.
The footage is not was of the actual shooting, but just
Okay. Well, it doesn't sound like there's really a witness to the event.
Not exactly, no. She was in the house. She heard the shooting. She didn't.
We had just somebody shot 8 times in the back.
from fire, which is from my sense comes from fire. She was, fine.
The state disagrees.
Yes.
Okay. Well, I'm sure whatever statement she made at the time of the scene, I you can help me if you have
I have it, Your Honor.
a written report. Maybe it's not there. If you don't have it, that's okay.
You can't find it right now.
If you can get it to the court,
I will, Your Honor.
but at this time, the court's going to make a finding that there's no information that's new that the court isn't always aware of, other than what was presented here.
Oh, I found it, Your Honor. If you'd like to.
You have a number 29, page 29. Huh. I'm looking at 30, and it looks like it's in the middle of the statement. Yep. is hard to follow because people's names are not used. We got a cheetah and a lightning, the names they go by, that are kind of hard to identify. Well, I'm reading this. Fourth is the other. To say that the household was dysfunctional, but overstood. Or all the way around. But what is clear is that 8 shots in the back or 8 shots to win for this one. Everybody shot in the back is it's a murder, especially 8 times. It's a ruthless murder. Person shot in the back has little opportunity to do himself. No. Circumstances are such that $900,000, whatever the bond is fair and the reason under the circumstances of the court is so I'm not changing. What do you want me to do?
This is on trial.
Set up the trial, it shall be done. Thank you. Thank you. Here are these affidavits of innocence that I anything else? We are in
The judge isn't mincing words here. 8 shots in the back is murder. Ruthless murder. That's a legal statement, but also a moral one. And when a judge speaks like this, you can almost feel the gavel dropping before the trial even begins. Bond stays at $900,000, no mercy.